Friend, father, lawyer, call Frank Bruno Jr., attorney at law.
Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law, estate planning, and probate attorney in New York. Today, I'm going to give you a probate primer. Before I get to that, if you have any questions, if you'd like to ask me anything about your unique situation, please reach out to me. Call frankbruno.com. Probate primer. Well, upon the death of a person with a will, the will must be probated. You can only have probate after a will. After a will is created, drafted, fully executed, and then upon the death of the decedent person that had the will. So how do you probate? Well, you have to go to the county where the person died or where he owned or she owned property. So you go to that county. Within that county, you have to have the original will. You take that will and you fill out, you complete a probate petition. Now, the court itself has the documents necessary. Some experienced attorneys like to use that form and type in the pertinent information. Other attorneys use their own forms. But basically, what you're telling the court is all of the pedigree information about the person, plus all of their heirs. That's who are their beneficiaries and who they are giving their assets to within the will, their devisees, right? So all of the people that are your beneficiaries and who you're giving it to, your stuff, they don't have to be one and the same people, right? It could be different sets of people. I have 3 children, but I'm leaving everything to St. Francis Hospital, right? Those would be 2 different things. So you have to let within the petition, you let the court know any persons or associations, organizations within your will. Now, you need your original will, you need your probate petition, you need to go to the proper county, and you need to file a fee. So the fee is set by the Surrogates Court Procedures Act, and the fee runs from $45 to $1,250, depending on the size of the estate. Now, you can have waivers, consent, and then you just file the papers and you wait. But if there is not consent by the persons that are in your will and your beneficiaries, then you need to have a different process. It's a bumpier process. You need to file a citation. So if you file a citation, you're going to get a court date and you have to follow the court process. Probate primer 2. Where there's a will, there's a probate. So in the first part, I mentioned that if a person has a will, they have to go to the county where the person died or had property. They have to complete a probate petition. They have to file the appropriate fee. And then they take the process that's required by court. Now, what I wanted to add at this point is that when you file the petition, you need an original death certificate, right? An original death certificate for the person, and the court will require a paid funeral bill. Okay? So those are, at this juncture, that's what you have to file with your petition. Along with those documents, we also need an affidavit of heirship. We need an affidavit of comparison, and we need affidavit from the 2 witnesses. So these are documents that are prepared in advance of filing, and an affidavit is a sworn statement. So there's requisite information that belongs in the 3 affidavits that I mentioned, and we submit that to the court. So in the big picture of the probate process, and if we break it down into 3 stages, and that's stage 1 would be appointing an executor. Stage 2 would be administering the estate, marshaling the assets, and stage 3 would be closing the estate. So we're still in stage 1. We're just filing the papers now at court. And if all concerned parties have signed off and are consenting to the named executor in the will, obtaining letters testamentary, that's the official court documents. If consent are signed, that'll complete stage one. I'll talk a little bit more about the bumpy road if there's no consent. I want to discuss contesting a will. So I'll give some information about that. The executor, in our story, the executor filed a will with the court, and we're waiting for the court to determine that the will is valid. Just because a will is filed doesn't mean that it's valid. We want the court to look at the documentation that we submitted and confirm that it's valid, and then to appoint the executor, and then the executor could go on to stage 2 and stage 3 of the probate process. So while we're waiting for the court to decide, a person with standing can object to the will. So they could do that two ways. They could, give the executor a little bit of, or the proposed executor, a little bit of a hard time and not sign a consent. If they don't sign a consent, it sort of throws the probate into a contested posture, because then the proposed executor has to file a citation and secure a court date, right? So the burden shifts to the potential objector to say, hey, the will is invalid for this reason. So the person needs standing. They need to have been either an heir at law, or a beneficiary of the will, or a prior beneficiary. Say there was a will from a few years ago that left them a percentage of the estate or a house or something. And in the most recent will, that person was written out of the will. So that person would also have standing. So you need to have standing. To object, you have to demonstrate what it is. And usually there's one of three grounds. One could be that you're alleging that the person didn't have mental capacity to sign the will. Another valid reason to object to a will could be that the will was not properly executed. So the will didn't conform to the requirements at law. We have incapacity, that the will wasn't properly signed. There are more reasons that a person could contest the will, such as if they thought the will was a forgery or a sham document, or something created specifically the purpose of committing a fraud. Lack of proper execution. There's a number of reasons why an objectant could say that the will wasn't properly executed. It wasn't executed by a lawyer, or the witnesses weren't there, or the person couldn't speak English, or didn't read the document. Mental capacity, right? That's a broad category. Why did the person perhaps not have capacity to sign the will? Forgery, sham, fraud, duress. Was pressure put upon the person to sign this will? That would go along with undue influence. So at a later point in time, I will give more in-depth coverage to perhaps some of these key possible objections to a will. If you'd like to speak to me about your unique situation, please go to callfrankbruno.com. Thank you.
Friend